ADR. Now, when you've got a civil dispute, usually before you go to court, the judge will expect you to have tried some ADR. And ADR stands for Alternative Dispute Resolution. And there's lots of different types of ADR, and they often help people get their dispute resolved amicably without having to go through court. And most types of ADR are cheaper than going to court. They're less public and less stressful. So it's better for the judge, for costs, and for the people involved to try some ADR. Now, the first type of ADR is negotiation, and negotiation can be between two private parties where they negotiate to resolve their dispute. It could be if you have a dispute with your neighbour, you might go and see your neighbour, speak to your neighbour, try and sort out some dispute about a boundary wall or a fence or something like that. You might be able to come to a compromise with your neighbour and avoid having to go to court. You might write a letter to your neighbour, negotiate through letter writing. You also might get a lawyer, so a solicitor or a barrister sometimes, to negotiate on your behalf. If negotiation fails, you've still got the option of pursuing your claim through the courts. Another type of ADR is mediation, and mediation is where two parties get together with a mediator and try and resolve the dispute. A mediator is someone who is trained in getting the two parties to come to a compromise and will help to get them communicating with each other. The mediator doesn't give an opinion, and they will only try and aid communication. They can't bring in a legal opinion, and they can't side with one of the parties. Mediation is often used for divorce cases, where it's obviously much better for the two people involved and for the children if they come together and resolve their disputes together, and the mediator will help them to do that in a calm environment. There's also a formalised settlement, and this is like a mini trial, and it's where both sides make a submission. So that means that they write down what they believe the outcome should be and why. And the executives, with help of a neutral advisor, will evaluate the two sides' submissions and positions and try and work together to come to a compromise. If the sides can't agree, then the neutral advisor will act as a mediator between them and help them. But sometimes, even if that doesn't work, what it does mean is, if that case has to go to court, the two sides might have sorted out some of their dispute before it goes to court, which will mean that their trial at court might be less complicated and much more straightforward. So for mediation, even if it doesn't work, there's still the opportunity to go to court. And there are mediation services available. Commercial mediation services, for example, the Centre for Dispute Resolution was set up in London in 1991, and many important companies are part of this centre and have agreed to use mediation to help settle their disputes. There's also online mediation services which people can use to get some mediation. And people tend to like to use mediation before going to court or instead of going to court, because the cost of mediation is a lot lower than going to court. So it's really worth trying to settle your dispute through this method. The disadvantages, however, mediation services might be £1,000. There's no guarantee it works. So you might have to pay out £1,000 and then still have to pay to have your dispute resolved in court. Conciliation is very similar to mediation, by which case it's two private parties with a dispute and a third person who kind of helps the two parties. The difference between a conciliator and a mediator, however, is that the conciliator can actually offer a basis for compromise, can give some legal advice to both sides, and the conciliator can play a much more active role in the dispute being resolved. And in industrial disputes that use conciliation, ACAS can give impartial opinion on legal positions. The next type of ADR is arbitration. Now, arbitration, there's two different processes that the word arbitration could describe. The first is where the courts use a more informal procedure to hear cases, and this is the way proceedings in the Commercial Court or the Queen Bench Divisional Court are described. The second meaning of arbitration is where parties agree to submit their claims to a private arbitration. And this is the type that I'm going to talk about, which is relevant to ADR. So where people choose to use arbitration instead of going to court. Now, the arbitration is governed by the Arbitration Act in 1996, and it's the agreement usually between two parties to have their dispute dealt with by someone other than a judge and a court. And the agreement to use arbitration to settle their dispute is usually in writing, and the way people have their dispute resolved when they agree to arbitration is actually completely up to the parties. So two parties will agree to have their dispute dealt with by arbitration, and this agreement can be made before the dispute or at the time of the dispute. Many commercial contracts include what's called a Scott v. Avery clause, and this is where parties in their original contract agree that in the event of a dispute arising, they will use arbitration. And where there is an agreement to use arbitration in the contract, then the Arbitration Act states that a court will not hear or deal with a dispute that's got it written into the contract that they're going to use arbitration. So in that case, the parties will have to use arbitration to deal with the dispute. Now, an arbitrator is someone who listens to the dispute if the parties have agreed to arbitration. And an arbitrator can be a professional arbitrator, or it could be an expert in that field. So if it's a dispute about agriculture or publishing, it might be an expert in that field who is appointed as the arbitrator. The parties both agree on the arbitrator and the number of the arbitrators, so you might have 3 arbitrators. But the Arbitration Act says that if you can't agree on how many arbitrators that you're going to use, then 1 arbitrator should be used. And the Institute of Arbitrators can provide a trained arbitrator, or like I said, the parties can choose an expert in the field. The problem with using an expert in publishing or agriculture or something like that is that whilst they may be better to listen to your dispute because they've got the specialist knowledge required, they might not have the legal knowledge. So that's something that the parties need to consider when they're agreeing to use arbitration and who should be the arbitrator. The hearing that you might have if you've decided to use arbitration to settle your civil dispute can be paper arbitration, so that means that both sides write down their views, their outcome that they want from the dispute and their side of the story, and then those pieces of paper and submissions are sent to the arbitrator decides and then makes a decision. Or it can be a hearing where everyone gets together and makes their opinions and what they want out of the dispute known to the arbitrator. So it can be as informal or as formal as parties want. And also, paper arbitration is great if you've got people in dispute who live quite far distances apart from one another, or the parties choose an arbitrator who also is not very close to where they are. The decision of an arbitrator is called an award, and the award of an arbitrator is pretty final, and there are very limited rights to appeal. The types of things that I've talked about are all alternatives to going to court, all alternatives to using the track system and the civil courts. So they are mediation, conciliation, negotiation and arbitration. I'm going to talk to you about another way that you can have your dispute resolved, and it is an alternative to court, but I wouldn't say it's it's like mediation or conciliation. So I would say it's not going to court, but it's not like some forms of ADR, because forms of ADR like mediation, negotiation, conciliation, if it doesn't work, you can go to court. Tribunals operate alongside the court system, and someone will go to a tribunal instead of going to a court. Now, tribunals were created with the development of the welfare state, and they were created to give people a way of enforcing their entitlement to certain social rights. So tribunals are used instead of courts, and tribunals enforce the rights which have been granted through social and welfare legislation, that's laws. And there are many different rights, such as the right to mobility, an allowance for those who are too disabled to walk more than a short distance, the right to payment if one was made redundant from work, the right not to be discriminated against because of one's sex, race, age or disability, the right of immigrants to have a claim for political asylum heard. So if you've got a dispute focusing around one of those things, then it's likely that your dispute will not be held in a court, but it will be heard in a tribunal. And the Tribunals, Courts and Enforcement Act of 2007 governs the work of tribunals. And this act created a unified structure for tribunals, which is the first tier tribunal to hear cases as the first instance, and the upper tribunal to hear appeals. So the first tier tribunal operates in 7 chambers or divisions, and it deals with about 300 cases a year. It's worth noting that employment tribunals operate separately, and the upper tribunal operates in 4 chambers, divisions, and it hears appeals from the first tier tribunal, and there is a further appeal to the Court of Appeal if that's necessary. Now, cases will usually be heard by a tribunal judge or by a tribunal judge sitting with 2 experts on either side. There is only legal aid is only available for certain cases, and they're cases where the dispute is about asylum rights or a mental patient not being detained. Now, the procedure of a tribunal is both sides must give an opportunity to put their case. In some tribunals, for employment, for example, in asylum, this will be done in a formal way, with witnesses giving evidence on oath or being cross-examined. Other tribunals will operate in a less formal way, and a few tribunals funding for legal representation is only available in a few tribunals, so sometimes applicants will not use lawyers but will present their own case. And where someone is not using or has the assistance of a lawyer, the tribunal judge must make sure that the applicant puts its case fully and they know the procedure of the tribunal and things like that. And the Administrative Justice and Tribunals Council, this was set up under the Tribunals, Courts and Enforcement Act 2007, and it replaced the previous Council on Tribunals, which had operated since 1957. And its duties include keeping the work of tribunals under review, reporting on the constitution and working of tribunals, and considering reporting on any other matter relating to tribunals. Now, some of the advantages of tribunals are that it's cheap, things can be dealt with much more quicker than courts, it's much more informal than courts, and often there will be experts in the area who are deciding on the dispute. However, some of the disadvantages of tribunals is that there is lack of funding available, so legal aid, and it's more formal than ADR, and there's more delays than using traditional methods of ADR like mediation and conciliation, but it is quicker than having your dispute heard in court.